If you are facing a domestic violence injunction in Florida, the clock is already ticking. You have 15 days or less before a final hearing that could strip you of your children, your home, and your rights. Here are the 5 critical steps you must take immediately to protect your future. Tip number 5. Treat evidence like your lifeline. Allegations are not facts. Judges rule on competent substantial evidence, not stories. You must preserve every interaction immediately. Save everything. Do not delete texts, emails, or call logs. Screenshots are good. Native files are better. Context is king. A text message saying, "I'm coming over," looks like a threat in a vacuum. But if you have the previous text from her saying, "Please come pick up the kids," that is your defense. Authentication. In Florida, you cannot just show a judge a phone. We must prove who sent the message. Save the contact information, the phone number associated with the text, and any context that proves the sender is who you say they are. Tip number 4. Legitimate purpose is your shield. Florida law defines harassment as conduct that causes substantial emotional distress and serves no legitimate purpose. Stop the noise. If you are texting her 50 times a day about saving the marriage, a judge may call that stalking. Business only. If you must communicate, restrict it strictly to legitimate purposes, like facilitating agreed-upon time-sharing or handling joint finances. If it doesn't serve a specific purpose, do not send it. Social media, do not post about her. Do not tag her. Do not look at her stories. Cyberstalking is a valid ground for an injunction. Tip number 3. No contact means 0. If a temporary injunction is entered, the no contact provision is absolute and broadly interpreted. The accidental meeting. If you see her at the grocery store, you leave immediately. The third-party trap. You cannot ask your mom, your best friend, or your new girlfriend to just call her and ask about the kids. That is a violation known as third-party contact. The consequences. Violation isn't just a slap on the wrist. It is a first-degree misdemeanor. You will be arrested and held without bond until you see a judge. Tip number 2. The 15-day window is your only chance. A temporary injunction is entered based only on her side of the story. You have a due process right to a full hearing, usually set within 15 days. Do not wait. We cannot walk into court on day 14 and expect to be ready. We need time to subpoena records, depose witnesses, and prepare your testimony. Continuances. If we need more time to get evidence, we can ask the court for a continuance, but the injunction will likely remain in place during that time. Tip number 1. A final judgment is permanent. You must understand the stakes of a final judgment of injunction. It is not just a piece of paper. It is a federal disability. Firearms. Under the recent U.S. Supreme Court ruling in United States versus Rahimi and Florida Statute Section 790.233, a final DV injunction strips you of your Second Amendment rights. You cannot possess a firearm or ammunition. Period. 100% custody loss. The court can award the petitioner 100% of the time sharing on a temporary basis. Once that status quo is set, it is incredibly difficult to undo. Presumption of detriment. A finding of domestic violence creates a rebuttable presumption that it is detrimental for the child to be with you. This shifts the burden to you to prove you are safe, a burden you do not want to carry. Bottom line, this is a legal emergency. Do not contact the petitioner. Secure your evidence. Contact nestlaw.com immediately so we can prepare for your hearing.